Hello friends, welcome to Drishti IAS 100 most important topics of current affairs for UPSC Prelims 2026. Myself Abhishek Mishra. So in the previous episode we discussed some of the important topics, and in this episode we'll continue with the same. So the topics that we are going to take up in this episode are three topics. One is the removal process of the speaker. It has been in news and important from exam point of view. Then Chief Justice of India and the removal of a Supreme Court judge, how the process is implemented, that we'll see. And thirdly, UPSC has been in news because it has completed 100 years. So let us look at these topics one by one. First of all, let's look at the position of speaker, which is very important in the Indian political system, right? So speaker is considered as the highest authority of Lok Sabha, right? And speaker also continues in office till the first sitting of new Lok Sabha, right? So even if the Lok Sabha dissolves, the speaker continues to be in office, and only just before the first sitting of the new Lok Sabha, which has been elected, the speaker demits his office, right? And the article which we need to know about the speaker is Article 93. It says that Lok Sabha will choose two of its members as speaker and deputy speaker, and their election will be done by the process of simple majority by Lok Sabha itself. Now the date of election of speaker is fixed by the president, while the date of election of the deputy speaker is fixed by the speaker, right? So this is also important, that the date of election of the speaker is fixed by the president, while once the speaker has been elected by the house, then the speaker will fix the date of election of the deputy speaker. Right now we are not having a deputy speaker in Lok Sabha since 2019. Right. Another important thing is that speaker is a very high constitutional position, and he comes at number 7 in the order of precedence in the official or ceremonial functions. So we can just here see the order of precedence for state and ceremonial occasions. So president is at the top, then vice president, then prime minister, then governors in their respective states, then former presidents, followed by deputy prime minister, chief justice of India, and speaker. And then we have the union cabinet ministers, chief ministers within their respective states, former prime ministers, leader of opposition in Lok Sabha and Rajya Sabha, all at number 7, and just after them are the Bharat Ratna awardees, right? So this is the order of precedence for ceremonial and state functions. This basically governs the protocol. Now the current speaker of Lok Sabha, Shri Om Birla ji, he has faced a no confidence motion moved by the opposition parties. The motion was ultimately defeated, but that is why it was in news, and a question is likely in the exam. So we should be aware that what is the process of removal of the speaker. Now the removal process needs the support of at least 50 members for acceptance, right? So the removal notice needs support of at least 50 members for acceptance, and it requires a written notice of 14 days to the Secretary General of Lok Sabha, right? So the notice, a 14 days notice has to be given before moving any such resolution. The notice has to be given to the Secretary General of Lok Sabha and not to the speaker per se. Now the charges in the resolution for the removal of speaker, they need to be specific and clear. They cannot be vague charges. So they need to be specific and clear. And also, once this resolution is accepted or admitted by the house, then there needs to be it needs to be passed by effective majority, right? So it is not simple majority, it is not special majority, but effective majority. What is effective majority? So effective majority is basically, we have, for example, the total strength of the house 100, right? I am just giving an example. So if the total strength is 100 and if there are vacancies 5, so effective strength becomes 100 minus 5, that is 95. So now we need the majority of this effective strength, that will be the effective majority. So this is how the effective majority is calculated. And for the removal of the speaker, effective majority, the resolution needs to be passed by effective majority of Lok Sabha. Also, very importantly, there is no role of Rajya Sabha in the process of removal of speaker, right? Whereas we had seen in, or we can just contrast that the removal of speaker with the removal of the chairman of Rajya Sabha. In that case, or vice president is the chairman of Rajya Sabha. So in his case, again the motion is initiated in Rajya Sabha, it is passed by a effective majority of the Rajya Sabha, then it has to be agreed by simple majority by Lok Sabha. But this situation is not there in the case of speaker. Only Lok Sabha takes the decision. There is no involvement of Rajya Sabha. Right. The articles involved are Article 94A, 94 Clause B and 94 Clause C. Article 94 Clause A says the speaker will cease to hold office if they stop being members of Lok Sabha. Right. So Article 94 Clause A says that the speaker will cease to hold office if they stop being a member of Lok Sabha. 94 Clause B says that the speaker can resign anytime, right? And for resigning, the speaker can write to the deputy speaker, and the deputy speaker can resign by writing to the speaker. Thirdly, 94 Clause C says the speaker can be removed by a resolution passed by effective majority of Lok Sabha, right? So this is the article which is in news for the removal process, Article 94 Clause C. So in general, we need to remember Article 94, but if we want to be specific, then it is Article 94 Clause C. Now, during the pendency of such removal notice, the speaker cannot preside. So to avoid any conflict of interest, the speaker cannot preside when a motion for his removal is under consideration of the House. But the speaker can participate as an ordinary member and can also vote in the first instance, but cannot exercise a casting vote. Casting vote means that the speaker cannot preside, but in case there is voting in the House, then the speaker can also vote in the first case. But if there is a equality of votes, then the speaker is not allowed to cast the decisive vote in such a case, right? So that we need to know. So speaker does not cannot exercise a casting vote in this case. So far there have been 3 cases of removal resolutions brought against the Speaker of Lok Sabha, and the 4th case was 2026 Shri Om Birla. Right. So now we can say that there have been 4 instances, right? Now 4 instances. So the first instance was in 1954, the first Speaker of Lok Sabha, Shri G.V. Mavalankar ji, 1966 Shri Hukum Singh ji, and in 1987 Shri Balram Jakhar ji, and now in 2026 Shri Om Birla ji. So there have been 4 instances now where the removal notice has been, or removal motion has been brought against the Speaker of Lok Sabha, but none of them have passed, right? So after having looked at the various provisions regarding the removal of Lok Sabha Speaker, now let us attempt this question. So the question is, consider the following statements and we have to identify the correct statement. Statement number 1 is, removal of Speaker requires the resolution passed by 2/3 majority of members present and voting. Statement number 2 is, a minimum notice of 14 days has to be given to Secretary General of Lok Sabha. Statement number 3 is, the Speaker can preside during his removal proceedings. The options are A, 1, 2 and 3 are correct, option B only 1 is correct, option C is only 2 is correct, and option D is only 3 is correct. So please write down your answer in the comment section. Now let's look at the CJI, Chief Justice of India. So last year the 53rd Chief Justice of India was appointed, Justice Suryakant ji. So he has become the 53rd CJI, and the appointment of CJI is done by President under Article 124 Clause 2. So this article is important, Article 124 Clause 2. Now how the Chief Justice of India is appointed? So CJI is appointed by following the seniority principle. The senior most judge of Supreme Court is usually recommended for appointment as the CJI, and this recommendation is made by the outgoing CJI to the Union Law Minister, and the Union Law Minister forwards it to the Prime Minister. The Prime Minister then advises the President. The final appointment is done by the President. Right, and the Chief Justice of India is also the master of the roster for Supreme Court. What is the meaning of master of the roster? So, master of the roster means that the cases in Supreme Court, which cases has to be allotted to which bench of the Supreme Court, that is decided by the Chief Justice, and also the composition of the benches, that is also decided by the CJI. So, that is the meaning of the term master of the roster. Now, very important for us this time is to know about the removal process of a Supreme Court judge. Now, the removal of the CJI is also same as the process for the Supreme Court judge, and for many other important constitutional authorities, it has been written in the constitution that the process will be same as that for the Supreme Court judge. So, the process of removal for Supreme Court and High Court judge is the same, and let us look at the process. So, the ground for removal of Supreme Court or High Court judge, including CJI, is proved misbehavior or incapacity, right. This is the ground for removal. Now, the process for removal can be initiated in either house of the parliament, Lok Sabha or Rajya Sabha, both houses have equal powers. So, the process can be initiated in either house, but two conditions need to be satisfied. That means that the motion for removal of a Supreme Court or High Court judge, it needs support of at least 100 members if it is to be introduced in Lok Sabha, or it needs support of at least 50 members if it has to be introduced in Rajya Sabha, right. So, this condition has to be satisfied. So, it can be initiated in either house, but if it has to be initiated in Lok Sabha, then support of 100 members of Lok Sabha is needed. If in Rajya Sabha, then support of 50 members of Rajya Sabha is needed. Once the motion is admitted, then the speaker or chairman, as the case may be, they will set up an investigation committee consisting of 3 members. So, who are these 3 members? So, the first member will be the Chief Justice of India or a Supreme Court judge, right, CJI or Supreme Court judge. Second member will be Chief Justice of any High Court, and the third member will be an eminent jurist, right. So, 3 members. First member can be a CJI or Supreme Court judge sitting, second member can be Chief Justice of any High Court, and the third member has to be an eminent jurist. Once this committee is set up, the committee will investigate the charges against the concerned judge, and the committee will report back to the house which has set up the committee. After that, if the committee finds the person to be innocent, then the process ends here. If the committee finds the judge to be guilty, then the voting is done in the initiating house. The motion has to be passed by special majority type 2, which is majority of the total membership of the house plus 2/3 majority of present and voting. So, this is special majority type 2, by which this motion has to be passed. Once passed in the first house, then it goes to the second house, where again it has to be passed by special majority type 2, that is majority of total membership plus 2/3 majority of present and voting. Once both houses have passed the motion, then the President issues an order removing the concerned Supreme Court or High Court judge. So, this is how the process of removal is done, and it is same for even the Chief Justice of India. Right. So, the process is very difficult and cumbersome for the removal of a Supreme Court or High Court judge, right, and this has been done deliberately to protect the independence of the judiciary, right. There have been 2 instances where judges have faced this type of removal process, but there has been no removal of Supreme Court or High Court judge through this process. Justice V. Ramaswamy faced this process in 1993. He was the first judge to face the removal process, but the motion failed in Lok Sabha. Then Justice Soumitra Sen in 2011, the motion was passed in Rajya Sabha, but before it could be voted upon in Lok Sabha, the concerned judge resigned. So he resigned before the Lok Sabha could vote on it. Right. Then we should also know about the appointment process. The appointment process of judges for Supreme Court and High Court, it is done through a system which is known as the collegium system. Now, collegium system is a judicial innovation. It is not mentioned in the constitution, and it has come about through three important cases which are known as the first judge's case, second judge's case and the third judge's case. So, the first judge's case was in 1981, where the Supreme Court actually held that the president has to consult with the CJI while appointing judges to Supreme Court and High Court, and the consultation is not same as concurrence, right. So, the Supreme Court said the consultation with CJI is important, but consultation is not binding on the president. That means the president is not bound by the recommendation of the CJI. So, here the primacy in appointment of judges was with the executive, right. Executive had primacy. Then we come to the second judge's case in 1993. Here the Supreme Court held, it made a U-turn and it held that consultation with the CJI means concurrence of the CJI. That means here now the Supreme Court changed its stance and said that whatever the CJI is saying, that has to be that is binding on the president. So, CJI's advice is binding, but CJI must also consult two senior most judges of Supreme Court before giving his advice to the president. So, this was the second judge's case. Then the government went for a presidential reference under Article 143, which led to the third judge's case in 1998. Here the Supreme Court again said that the collegium system is right, but it modified the system. It said that collegium will now include CJI and 4 senior most judges of Supreme Court, and the advice will remain binding. Also in the second judge's case, the Supreme Court had said that for the appointment of CJI, the senior most principle will apply. The senior most judge of Supreme Court will become the CJI. So, this was also stated in the second judge's case. So, these three cases are very, very important. Right, and the name of these cases, so the first judge's case is actually known as the SP Gupta versus Union of India case. In short, it is known as the first judge's case. Second judge's case is SCARA. SCARA stands for Supreme Court Advocates on Record Association versus Union of India case 1993. And third case, RE means presidential reference under Article 143, special reference 1 of 1998 case. So, it was a reference case under Article 143. So, these are the three judges cases. Now, the composition of collegium, Supreme Court collegium, it comprises of CJI plus 4 senior most judges. The High Court collegium, it comprises of the Chief Justice of the High Court plus 2 senior most judges of High Court. Right. Now, let us look at these this question. So, which of the given statements are correct? Statement number 1, CJI is appointed by the President of India. Statement number 2, the process for removal of CJI is same as that for a Supreme Court judge. Statement number 3, seniority principle is followed in the selection of CJI. So, you have to select from these 4 options. A is 1 and 2 are correct, B 2 and 3 are correct, C 1 and 3 are correct, and D 1, 2 and 3 are correct. So, you can write your answer in the comment section. Thank you. Now, let us come to the third topic, which is about UPSC. So, UPSC is marking 100 years of its existence in 2026. So, UPSC was established in the year 1926, first time on the recommendation of Lee Commission, right. Lee Commission gave its recommendation in 1924, and based on its recommendation, a public service commission was set up in India for the first time in the year 1926 under Government of India Act 1919, right, also known as the Montagu-Chelmsford reforms, right. After this, the Government of India Act 1935 changed Public Service Commission into Federal Public Service Commission. And this Federal Public Service Commission later on became the UPSC in 1950. Right. So, it was Public Service Commission on the recommendation of Lee Commission, right, set up in 1926. Later on, under Government of India Act 1935, its name was changed to Federal Public Service Commission, and then in 1950 it became UPSC, right. So, PSC, then FPSC, and then UPSC finally. Now, the UPSC is the provisions related to UPSC are present in part 14 of the Constitution from Article 315 to Article 323, right. So, this is the composition of part 14. It also contains articles relating to services of the Union. Then UPSC has recently come up with a initiative which is called as Pratibha Setu initiative. So, many aspirants who reach up to the interview stage of UPSC Civil Services exam, so they are considered to be of high caliber, but unfortunately they have not been able to make it to the civil services. So, rather than letting this talent go waste, what UPSC has done, it has come up with the Pratibha Setu initiative, which connects the interview qualified candidates to alternate employment opportunities in public sector enterprises and even for private sector. So, it contains maintains a database and it shares the database with interested companies and organizations. Right. Now, UPSC under Article 316, it comprises of chairman and other members appointed by the president. So, chairman and other members of UPSC are appointed by the president, and every member holds office for 6 years or 65 years of age, whichever is earlier. So, that is a standard thing for the UPSC members and chairperson. And Article 317 says that the chairman and member can be removed on grounds of misbehavior, right. So, they can be removed on grounds of misbehavior. Earlier we have seen that the Supreme Court judge can be removed on grounds of misbehavior and incapacity. Two grounds are there, but here only grounds of misbehavior is there. Then Article 319 bars or stops the chairman from further employment either under Government of India or Government of State, right. So, they cannot take up any further employment within Government of India or within the state government. Now, members are also ineligible for reappointment, but members can be appointed as chairman. So, that is the only difference. Chairman, no further employment with the center or state. Members can be appointed as chairman. Now, let us look at a question. So, consider the above the below statements. Point number 1 or statement number 1 is the provisions relating to UPSC are present in part 14 of the Constitution. Statement number 2 is every member of UPSC holds office for 6 years or 65 years of age, whichever is earlier. Statement number 3 is the first Public Service Commission was set up in 1926 on recommendation of Lee Commission. Now, we have to identify which of the statements are not correct, right. So, see, here I have deliberately changed the statement, or what normally I have been asking that you have to identify the correct statement, but here it is which of the statements are not correct. So, even in exam you need to be very careful and you need to read the question, because many times what happens when we are reading such question, we assume or we presume that the question will be asking us the correct statement, right, and in our mind we start identifying the correct statement, but we have to read the question till the very end, right, very calmly, because otherwise we'll, even after knowing, we'll end up marking the question incorrectly and we'll lose the sure shot marks as well as we'll incur negative penalty also, right. So, we need to be very careful. Please attempt this question and write down your answer in the comment section. I'll see you with some more topics in the later episodes. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.